Good afternoon, everyone. Thank you for joining us. For those of you I've not worked with before, I'm Christine Wobig. I'm one of the workers' compensation attorneys at Meshbesher Spence. By way of background, I've been doing workers' compensation law since law school, where I clerked at a local plaintiff's firm starting back in 2007. After I graduated, I continued to do plaintiff's work at another plaintiff's firm in town. I've also spent some time on the insurance defense side, so I've handled some cases for employers and insurers, which has given me a very diverse background and a good insight into what is compensable and what's not in a workers' compensation claim. Happy to bring my plaintiff's practice back over to Meshbesher Spence.
And I'm Ashley Bierman. I have been on what I like to call the good side the entirety of my career. I started practicing in 2014. I've been exclusively workers' compensation, PERA disability, MSRS disability since I was licensed in 2014. Prior to that, I was law clerk for some personal injury firms and workers' compensation firms around the area. So I've been doing this stuff about 10 years.
We're happy to have you all here, and we hope you have some questions for us in the feed. So we'll go ahead and get started and answer some of those questions. Our hope today is to give you all a general idea of what goes on in a workers' compensation case and what you can expect as we move forward in the process. And for those of you who may not be working with us or have just started the process, this should hopefully give you some good insight into that.
Yeah, absolutely. So hopefully we can get some good conversations going today. We can get some of your burning questions answered. We have an awesome producer here today that's going to let us know some of the questions that are coming up on the feed, and then we'll kind of go from there.
All right. Eric, what do you have for us?
All right. So first off, if you could describe a little bit about what the workers' compensation structure looks like after someone's been injured at work, that'd be great.
Do you want to take the first one, or do you want me to do it?
I'll go. So workers' compensation, it's kind of like a choose your own adventure because there's a lot of different paths that a workers' compensation claim can take. It largely depends on whether your claim is admitted by the employer and insurer or whether it's denied. If you have a denied claim, the path it's going to go down is pretty straightforward. We are going to file a claim petition on your behalf. Once we file that claim petition, you can expect to participate in some discovery. You'll have your deposition taken most often. The employer and insurer will set you up with an independent medical examination with one of their physicians to evaluate you. At some point in the process, you'll then have an opportunity to discuss settlement of the claim. That usually comes, I would say, on average about 6 months after we file the claim petition, give or take on either end, depending on the court calendar. And if the case settles at a settlement conference or a more extended mediation, then your claim's done and we wrap it up through the settlement process. If it does not, then we continue to proceed to a hearing. I would say on average, Ashley, and you can correct me if I'm wrong, but a typical claim petition from when we file it until it's resolved through a hearing, not necessarily settlement, which comes a little sooner, but through a hearing, is a good 10 to 12 months on average. There's exceptions on both ends, but I'd say plan on 10 to 12 months if you have a denied claim and we're filing that claim petition on your behalf. Now, if your claim is admitted by the employer and insurer, there's a lot of different potential paths that could possibly take. So if they have admitted all of the benefits, you might just sit and collect your wage loss benefits that they're paying you, submit your claims for the medical bills, work with your QRC, and we help you in that process. Just monitor to make sure everything's paid. If there's disputes, there's a different dispute process for admitted claims. And do you want to talk about that?
Yeah, for an admitted claim, the process isn't maybe as structured as a denied claim in some ways. And I will say too, depending on, before I jump into the admitted claims, I'll just piggyback on what you said on the denied claims. If we're talking about an orthopedic injury, fairly straightforward, then I completely agree with Christine, like what Christine just said. There are some areas of work comp that are a little bit more complex. One of those areas, in my opinion, is post-traumatic stress disorder, and we handle a lot of those cases. So if we're layering a PERA claim on, we typically handle that first, which obviously will slow down the work comp process, but for strategic reasons, it does make sense to kind of structure it that way. In addition, a lot of times it is more difficult to get expert opinions on those post-traumatic stress disorder claims, not because people won't render the opinions, but they're just in high demand right now. So practically speaking, it just takes longer to get people in and out of those independent psychological evaluations and things like that. Admitted claims, I don't have a lot of those, frankly.
That's true. That's
But-
true. We are seeing mostly almost all PTSD denials at the time. So admitted claims, you might have some administrative conferences as we go along the way. Your insurance company might be paying everything, and then all of a sudden they decide they don't want to pay for an injection or they don't want to pay for surgery. So we send the dispute over to the Department of Labor and Industry. We get that certified, and then we have a conference on that. Depending on the results of the conference, it either marches forward to a formal hearing on the matter or it resolves itself and the bill gets paid. So there's a complex path that those claims can follow, and we're happy to answer any questions that you have about those. They're very case specific. So at any time, again, feel free to reach out to me, my staff, Ashley. We can just tell you over the phone or by email exactly what you need to know.
For sure. And if you have a permanent injury, even if it's an admitted claim and you think that work comp is paying all the benefits, it's still a good idea to check in with an attorney, because we do things like make sure they actually are paying you everything that you're entitled to. You haven't heard about medical mileage and that you should be getting reimbursement for that? Weird. The adjuster didn't tell you. They might not.
Right.
In addition, a lot of times adjusters will calculate an average weekly wage in a way that maybe is not correct, or it's kind of a lazy way of calculating it. And we want to make sure that we're maximizing that average weekly wage for you, because it's what your wage loss benefits are based upon. And we want to make sure that you're getting all the money that you're entitled to. So that's why it's important that even if your claim is admitted, that you call an attorney if it's a permanent injury, especially, and just check in and see that everything's handled appropriately.
And one thing I would add, just to piggyback on that too, is I hate to be the bearer of bad news, but it is entirely possible that you have an admitted work comp claim for your life. So you might have an old injury from 10, 20 plus years ago, and all of a sudden there's some dispute that rears its head that needs to be dealt with 15 years into the process, and that takes its own course. So don't be alarmed by that if that were to happen, and we're always able to help with that.
We literally just had a Minneapolis police officer from like the 1970s, I believe, date of injury call in, and we're assisting that individual. So it never hurts to check in.
It happens.
So the next question is about whether your claim gets denied, or what happens when your claim gets denied. What does that look like, and what's the timeline that can come out from that?
Yeah, I think Christine, answered some of that. I think that, if it is, a first responder, post-traumatic stress disorder case, one thing that I'll say is it's very normal for your case to be denied. I mean, I've handled hundreds of these types of cases, and I can count on one hand the number of cases that have been initially admitted, despite the PTSD presumption here in Minnesota. So my advice is, number one, don't panic. Just call someone who understands PTSD, and they can assist you with the process. But depending on whether there's a PERA claim involved or not, that process is going to look a little different. If you do have a PERA disability or an MSRS disability component, we would tackle that first and make sure that we're handling that claim and getting you through that process to get you approved for the PERA disability benefits. That's the monetary benefits that for most people will serve as income replacement. And then we also make sure that the health insurance at that point is picked up and paid for underneath a separate statute, Minnesota Statute 299A.465, deal with any issues that can arise there. And at that point, once we know that that's secured for you, that's when we would initiate that lawsuit in workers' compensation against the employer insurer. And there, again, are strategic reasons for that. So denied claim, don't panic. Obviously, we'll fight that fight out with the workers' compensation, but we want to make sure that we're securing these other benefits for you first. And then that denied claim, once we initiate and file that claim petition, we'll follow that exact path that Christine just explained, where sometimes in these PTSD cases, I feel like it might be about a year until resolution. I feel like that's probably the average. It's great if we can get it done in 9 months. It can certainly take up to a year and a half if we're litigating it, sometimes longer if there are complications. But we try and get through those things as efficiently as possible for people.
How about pain and suffering? Is that something that's available in a workers' compensation type of claim?
For those of you who can't hear, the question was, is pain and suffering available for workers' compensation claimants in their claims? And I'm sorry to be the bearer of bad news, but no, it is not. There is no pain and suffering in workers' compensation. Workers' compensation was designed to be a no-fault system. So it's very different than the civil system, which our esteemed colleagues handle cases within. We are working within a no-fault system. It does not matter if the employee was at fault for the injury. It doesn't matter if the employer was at fault for the injury. All that matters is that the injury arose out of and in the course and scope of one's employment. So if that happens, we have more or less met our burden of proof, and we don't have the ability to then claim things like treble damages or punitive damages. They're just simply not available to injured workers outside of a very limited subset of claims that have a third-party action.
Yeah, and I've always heard that described as kind of like the compromise of workers'
Right,
compensation,
exactly.
right? So we don't get our awesome, pain and suffering damages that, our PI folks can get after amazing jury verdicts, things like that. But we do have permanent partial disability. I think that's supposed to be kind of the substitute in workers' compensation.
Exactly.
And it's very structured. The way that that is set forth is you look at what I describe as the most boring book in the world, but essentially it's a list
Right.
that goes through different body parts and different injuries, conditions, things like of that nature. And it is associated with a certain disability rating. You run that through a modifier, do some math. We got tricked. I didn't think we'd be able to or have to do math in this, but you do.
Right.
And essentially that correlates with a certain lump sum number that's supposed to be reflective of, it's not pain and suffering, but essentially loss of use or function of that body part. And when you're talking about post-traumatic stress disorder, obviously we're not talking about quite the same thing. It's more a focus on that functionality piece of it, and that's rated as well.
Right. So that's supposed to be the I'm sorry you had this injury piece of the puzzle. And that's what we're stuck with in work comp. So we'll make sure that we find what that number is and work with your health providers to get that rating for you.
Yeah. So no pain and suffering, but we do get PPD, and we'll make sure that we'll maximize that for you.
Right.
What about future pain or future medical expenses and future wage loss? How does that play into a workers' compensation claim?
So workers' compensation is very much an ongoing benefit system. Like I said before, it is entirely possible that someone gets hurt at work, and if the employer and insurer pay benefits, you might just simply have them pay out benefits over the course of your lifetime. You may be in and out of wage loss, where they pick up wage loss here, you go back to work, you have another surgery, they pick it up again, you go back to work. Or you have medical, especially with, for example, like low back injuries, those tend to stick around for a while. So you may have an injury at one employer, have a pretty significant disc injury, and feel okay for a while. 10 years later, it comes back up, and you have to go back to the insurer, and a lot of times they'll pick it back up. So you could just be stuck in this ongoing benefit system, which is technically what the system is supposed to do. Yeah. In terms of future medical benefits, future wage loss, this isn't a system where we can go to a jury and say, this person is going to lose out on X amount of dollars in wage loss over the course of their career because of this injury. It doesn't work that way. But how we do handle it is if we go to evaluate the claim for a lump sum settlement, which is voluntary on both ends, we look at the various statutory caps. For example, there's 130 weeks of temporary total disability benefits that are available. Even if you're totally disabled beyond that, that's the cap for that. Another benefit might kick in at that time, but that's the cap. So we go through these benefit caps, we figure out how many weeks are left, we multiply it by your compensation rate, and we project all of those numbers for the insurance company. If it's a situation where it's a denied claim or there's a dispute over medical and the closure of medical is on the table, then we look at the severity of the condition, what type of lifelong treatment one might be looking at, and project a value from there and ultimately reach some sort of compromise if possible.
Well, every case is different. For some people, it might not make any sense to close out that future medical, which means 20 years from now, you might still be getting your surgery for your back paid for by workers' comp. For that wage loss piece, I think what Christine said is spot on. We have to be mindful of the fact that there are wage caps that apply in workers' compensation. For temporary partial disability, when you go back to work but you're earning less money, you can never if depending on your date of injury, but assuming it's a more recent date of injury, you can never earn more than 275 weeks of that benefit. After that, it's capped out. So essentially 5.2 years is what that equates to. And another point that, I think is important is if it's a denied claim and we're looking at trying the case and we're kind of weighing settlement versus, trying the case and being successful there, you still have to remember that a judge can only award, they only have jurisdiction to award benefits through the date that they hear the case. They cannot award future benefits at that time. You get kicked into that admitted claim status, and essentially you're going through and you're collecting, each week benefits over the course of time. They can't, issue you a lump sum. So that's a conversation a lot of times with clients when we're looking at settlement is, what do you want your next 5 years to look like?
Right.
Does it make sense from that perspective too to settle versus go to court? And so that's kind of an element that we always discuss in a mediation and a settlement conference with our clients to make sure that we're doing what's best for them.
Right.
All right, so the next question is about someone that's been hurt at work, and work comp has been paying what they say most of my benefits. At what point should they be considering consulting with a lawyer or hiring a lawyer following a work-related incident or work-related injury?
Yeah, I would say that following a work-related injury, if you have any questions, you can always reach out to a lawyer. There's no downside. It's completely free to consult with a workers' compensation attorney, and we'll spend the time to make sure that you're getting paid all the benefits that you should be getting paid, and that those benefits are appropriate. So like we talked about earlier, average weekly wage. Everything is based on that. We make sure that you're being paid appropriately in that way. I would say, all work comp attorneys are a little bit different, but I think you and I work together kind of similarly that way.
Yes.
Where if it's a permanent injury and we know it's a permanent injury, likely to be severe especially, we'll jump on the case right away, even though, you might not necessarily need us until down the road, but we're monitoring the case to make sure that nothing goes wrong in between. We can kind of protect and make sure that your case, you're getting the right advice throughout this, and we don't fall into any pitfalls or anything like that that would make settlement or going to court when a dispute does arise more difficult. So, the short answer to that is always ask questions if you have questions, and certainly we're willing to pick up and monitor claims and become your attorney when we know it's going to be a permanent injury because it behooves you in the long term and it makes sense.
Yep. What I always tell the individuals that I consult with is one thing to remember throughout this process is that you are one person, you are the employee, you are an individual. Your employer and the insurance companies are corporate entities.
Yeah.
They have attorneys. I assure you they are consulting with those attorneys. You don't know it, but they're getting their marching orders. Even if it's the manager you deal with every day, that person's getting their marching orders from HR, who has its own counsel. The insurance company has outside counsel, in-house counsel to monitor your claim, and they are doing that. So it really does behoove you, I would say, when in doubt, ask. And even if you're not in doubt and think everything's going okay, it's okay to ask too. You shouldn't feel guilty or bad or like you're being overly aggressive because there are lawyers involved in the process already. You just probably don't know it.
Well, how many times do we hear well, I've never had to consult with an attorney. I never wanted to get an attorney. Like, you're doing something wrong. And I guarantee you, just like Christine said, they have that help on their side. And this is what they do for work. They're already kind of experts in work comp, if you will, and they have all the information. You're the one kind of at a loss if you don't have that information. So there's nothing to feel bad about there.
Right.
What happens if my employer responds to my work comp claim in a negative light?
That's a good question.
Employers cannot retaliate against you for bringing a workers' compensation claim, period. That said, none of us can make your employers be nice people. We can't make them be polite to you, but we do want to make sure that you are not being retaliated against. And your employment is very closely tied to your workers' compensation claim. However, your employment and your work comp claim are technically separate matters. If we see some red flags, for example, if someone, and I've had this happen in recent months, if someone gets hurt at work and surprise they're terminated 3 days later, that's a major red flag. We're going to refer you out to trusted employment law counsel. And in this case I did, and sure enough that person did have a retaliation claim, and he worked with outside employment law counsel that I referred him to, and that employment law attorney was able to settle that matter for that individual. So the answer is no, they cannot retaliate against you. We can't make them be nice. We can't make them be reasonable. But there are certain protected classes, and we will help you monitor that along the way. We'll listen to your concerns, and we'll give you direction on as to where to go with that information.
Absolutely. And I would say, like, the only thing I can think of to add on to what Christine said is, you know, they can't change up your shift hours, you know,
Right.
in extreme ways, like, especially if you have childcare, other things. So they're not allowed to do certain things. There are certain case law that apply to certain types of issues that we might be able to help you with within the work comp system. But certainly, if it's egregious, it's going to be employment law, and we'll be able to get you connected to an expert in that area.
What about if the employer is giving, the word is ridiculous tasks, when it comes to light duty or restricted duty type of work?
Counting paper clips.
Counting paper clips, cutting circles. We've seen it all.
Well, my answer to that is it has to be within your restrictions, right? If something is within your restrictions, they're not changing up those work hours like we told you before. I think that they can change up your job duties as long as it's within your restrictions. A lot of my people, especially my first responders, because they do not like being behind a desk at all, really get frustrated with light duty. And I don't blame them at all. That's not what they signed up for.
Right.
However, we want to be patient in that process, you know, within reason. And I do always kind of tell my people, hey, be patient. This is a process. And a lot of times we do, as long as it's within those restrictions, have to work that light duty job and do some maybe ridiculous things within reason.
Right. And Ashley's exactly right. The only thing I would add to that is in Minnesota, if your employer is able to accommodate your restrictions and they make you an appropriate offer of light duty work that's within those restrictions, and you don't take it, your benefits are in serious jeopardy, and it's very hard to get them back at that point. So you really do want to be accepting any reasonable light duty job offer that comes your way. And light duty can really be anything. A lot of the bigger companies do contract with volunteer agencies, so it's not abnormal for us to see, for example, commercial truck drivers injured on the job, and all of a sudden their new job is to be placed at someplace like the Salvation Army doing volunteer work, and they're technically paid hourly for that through this third party. And that's acceptable in Minnesota, and if they were to turn that down, their benefits would be cut off almost assuredly.
Yeah, that job offer defense is a scary one.
It
So
is,
make sure you
yes.
check in with us, your QRC, all of the above before you say no and refuse a job offer.
All right, the next question focuses us on PERA. What is PERA and how does it differ from work comp, if at all?
Yeah. So PERA is, it stands for Public Employee Retirement Association. And then there's also MSRS, which is Minnesota State Retirement Systems, Minnesota State Retirement Systems. And essentially these two things are pension plans for, you know, public employees. So MSRS is for, you know, people like state troopers, like corrections officers. PERA is more, you know, police officers who might work for a city or a county, paramedics working at HCMC, again, correctional officers. And so those people who have PERA or MSRS might have an additional claim, PERA or MSRS disability, which is completely separate from their workers' compensation claim. And it really provides, in my opinion, a lot more benefits for these people because it's a lifetime benefit. For many, it's income replacement or close to it. And I can go through the specifics of how that's calculated. It's based on essentially whether you're under the police and fire plan, the state trooper plan, or a correctional plan. They're also coordinated in general plans. And so each one has specifics that are tied to it. But essentially, if you're someone who's covered by MSRS or PERA, you want to make sure that you're a retaining attorney that understands PERA and or MSRS in addition to workers' compensation, because there's significant interplay between the two claims. And if you are not handling that properly and maximizing those benefits, then you could be losing out on a significant amount of money. So that's what those claims are. And essentially, the short answer is if you have one of those, make sure that you're consulting with an attorney to make sure that they're going after that disability claim for you as well, in addition to that work comp claim.
How about health insurance? Where does that come into play?
So if we're talking about like just health insurance, you're an injured worker, you get injured at work, there's a federal protection under COBRA, which is more employment law, but essentially that holds your benefits, including health insurance, in place for a period of 12 weeks. After that, work comp, the employer does not have to continue to pay your health insurance.
It's highly employer specific, and it totally depends on the internal policies. So some employers will be good Samaritans and they will cover it the entirety of a medical leave voluntarily. Others will not. Some will make injured workers pay extra premiums to cover that. Some will not. So after the protected period, it's a gamble. We just simply don't know until we go to your human resources department to figure out what the deal is.
Yeah, absolutely. And then again, for these PERA disability claims and MSRS disability claims, if you are a first responder and you are awarded benefits, you are entitled to Minnesota Statute 299A.465 health insurance benefits, which essentially that provides first responders with employer-based coverage. So the employer continues to have to pay their share of your coverage through the age of 65. And if you have dependents on your plan at the time, so you have a family plan, the employer has to continue to pay their coverage as well, pursuant to the internal policy. Obviously, once your kids turn 26, they're off that policy. It's the same rules, but they are entitled to, or they are responsible for paying your health insurance coverage through the age of 65. So huge benefit there, and very different from what I would say the average, civilian work comp claim.
So if someone's injured in a work situation, whether it be first responder or not, what kind of fees can they expect to incur when they hire a lawyer?
We, as do most workers' compensation attorneys, we work on a contingency fee basis. What that means is that if you choose to hire a workers' compensation attorney at our office, you are not coming up with any new money out of pocket to pay us. We are only getting paid if we recover disputed benefits on your behalf. So if you come to us with a permanent injury, and it's one of those claims that Ashley mentioned that we'll agree to monitor as we go along, we're not going to take a fee out of what they're voluntarily paying you. Yeah. If at some point they cut off those benefits and we have to go to court to get those benefits back, our contingency fee is 20% of those benefits. The maximum contingency fee is $26,000. So it's 20% of any disputed benefits that we have to go get for you, or 20% of a settlement. There are some circumstances where the only issue might be a surgery, for example. If they're paying everything, but they decide they don't want to pay for a surgery, and we go to court and we get that surgery covered under workers' compensation insurance, we can send the employer and insurer a bill for our time, and that would be a non-contingent fee. So that's nothing that comes out of your pocket. That would be billed directly to the employer and insurer.
Yeah.
Is that something that's paid up front at the time of engagement, or is that something that's paid on the back end of things?
It's always contingent. So we don't get paid unless we win for you, unless we get monies for you, either through, litigation and we win for you in front of a judge, or through, a settlement that you agree to and you want to engage in that we got for you. And one thing that I'll say too about the fees that are not necessarily coming out of your amounts, that 20%, when we're talking about disputed medical benefits or rehabilitation benefits, like Christine mentioned, those we get to submit directly to the insurance company, and they pay us essentially an hourly amount for that. And the nice part about having an attorney in the file and being able to file for those types of fees is I feel like it keeps insurance companies, municipalities, a little bit more honest when they're denying things. They're not going to deny things as frivolously if they know that we're going to go in there and win the benefits for you. So not only are they going to have to pay for that surgery, but they're going to have to pay for us as well in our attorney's fees. So in that way, we can really make sure that insurance companies are being honest and not denying your medical claims or your rehabilitation claims frivolously.
Yep. It definitely creates an extra exposure to the employer and insurer to have to pay us hourly, so they're going to think long and hard whether it's worth it to deny something before that comes into play.
Yeah.
The term QRC has been thrown around a little bit. What does that mean? And if a QRC has been assigned to a claim, what do I need to look out for?
I am a QRC evangelist. I love QRCs, and I think everyone needs to have a good QRC on their file. A QRC is a qualified rehabilitation consultant. They are someone who will go to doctor's appointments with you. They will help you coordinate all of your appointments. They will help you communicate your restrictions and serve as a liaison between you, your employer, and the insurance company, because it is a lot of logistical and administrative work for someone to keep submitting that and keep everyone in the loop, keep everyone on the same page of, what Joe Schmo is able to do after this appointment and whether there's any work available for you. They take that off your plate so that you have some time to heal and just go to your doctor's appointments and get better. Yeah. One thing you need to watch out with QRCs is they're all lovely people, but it is important that you get your own referral for a QRC. If you have an admitted claim, you're happy with the way things are going, and you don't want an attorney involved, and all of a sudden the insurer calls you up one day and says, hey, you know what, you have work restrictions related to the work injury. You still can't go back and do your date of injury job. We're going to put a QRC on the file. That is your signal to call a workers' compensation attorney and get their opinion on the on the situation. And we can give you our insight as to who might be a good QRC on your case. Yes. We can send a referral directly to the QRC. So even if you don't want to work with us, you'll get a good QRC. And the QRC will then reach out to the insurance company. They'll do all the heavy lifting to make sure that their consultation and services are paid. It's not a benefit that you pay, it's a benefit that the insurer pays.
Yeah, mic drop, 100% true. The only thing I would add is if you get a QRC assigned by your insurance company, when the rubber hits the road, not going to be your friend. They're going to side with that insurance company because they are the ones providing that QRC with the business, right? And we only have a certain amount of time to switch QRCs. You do have the absolute right to switch QRCs, but after that time elapses, you're stuck with that QRC. So make sure if the insurance company assigns one, you're making that call.
Right.
If someone's been hurt in a work-related incident, when should they contact a lawyer?
Now. Like I said at the beginning, I mean, honestly, it never hurts to reach out. If you really have questions, it is a confusing system. Workers' compensation is not intuitive. I learned that when I first started out in this practice, 10 years ago. So even if you don't think you need a lawyer, that's totally okay. There's no pressure. We want to make sure injured workers in Minnesota are being taken care of. So truly call and ask your questions. And sometimes it makes sense to have an attorney come on and monitor. Sometimes if it's a denied claim, well, not sometimes, you need to call right away so we can get that claim filed for you in that case. But don't think about it too much. Don't have that Minnesota guilt kick in and be like,
right,
I don't want to cause an issue. It's confidential. It's free. There's no downside. Get your information.
We want to talk to you, so please do call. We'll give you our honest opinion one way or another and what we think you should do.
The final question I have for you, I think you may have answered it, but is there any cost for having the consultation or the phone call initially?
Free. It's $0.
Yes.
So absolutely no obligation to sign up. We are not going to call and harass you. There is $0 to sign up to consult with us, ask all your questions. No obligation, all confidential. So there's, again, no downside.
There isn't. And like Ashley said, we're all nice Minnesotans. We don't want to rock the boat. So don't feel, guilty for taking our time or anything. This is our job. This is what we do all day. And this is why we have our job. It's what we like to do.
Yeah.
We'll help keep your claim on the straight and narrow.
Absolutely.
All right. Well, thank you all for giving us the information. We're 5 minutes past already. Amazing how fast this has gone. But if anyone else has any more questions or comments or concerns for Ashley or Christine, by all means, feel free to reach out to us at Meshbesher Spence, and we're more than available to you for consultations. Thank you all.
Always. Thank you.
Bye, guys.